And now we'll cover compliance plans. And this topic in general, it's hard to rank the importance of all of the topics that we cover, but nowadays you could argue that there's nothing more important than being compliant from a regulatory standpoint as a medical practice. So the core of this that we'll cover is the importance of a compliance plan itself. So and how to create a culture of compliance within your practice and why that's so important in today's world. So the good news is regarding compliance plans is it's one of the sort of areas where the government has actually given us an instruction manual of sorts to assist with when it comes to compliance. It's also one of the few areas where the government has said, if you have a compliance plan in place and if you adhere to it and something bad happens, we will actually look upon it favorably, that you had a plan in place and that you were adhering to it. And we have actually seen that anecdotally at work. I've been in situations where the existence of a compliance program and its use significantly changed the penalties and the headaches associated with issues, because sometimes you just have bad apples and you just have bad situations that arise. And you want to be able to show the government that you're not one of those people, even if it happens within your practice. So with that as a relative framework, we'll dive into the world of compliance plans. So what we'll cover is the OIG's guidance on compliance programs for individual and small group physician practices. As I mentioned, the OIG is actually, the Office of Inspector General, I should mention. They are the government agent, the federal government agency that is charged with overseeing fraud and abuse at the federal level. And they, several years ago, promulgated guidance for several different kinds of healthcare providers, labs, nursing homes, and also individual and small group practices. And so we're going to focus, of course, on their guidance as it relates to compliance programs for small and for solo and small practices. And as I've noted here, the government in its guidance is focused on voluntary measures that a practice can take that are related to claims that are submitted to federal healthcare programs, which, if you're a physician or physician group in Florida, you most likely are filing claims to federal healthcare programs such as Medicare or Medicaid, which involves federal money, or TRICARE, things of that nature. You can also, of course, tailor your compliance program to also cover private payer claims, because generally what we see in many forms in the compliance world is that the private insurance contracts generally, when it comes to compliance and procedures for compliance, tend to follow what the federal government does. So this would be a good example. A lot of these things you'll see when we talk about sort of more of the meat of the compliance program and some of its practical application, you'll see that it's something that can assist not only with claims that are related to federal programs, but really can apply to any claims and any of the goings-on within your practice. There was an attempt at sensitivity to the limited financial and staff resources that small and mid-sized medical practices have, but what we have found is even large ones have the same headaches. They're just, the numbers are larger, the overhead's larger, the number of people impacted is larger. So it really goes across the board, and I think all of these things do apply across the board. The complexity can often be more significant for larger practices, but at the end of the day, these things apply to any medical practice. And there is a push here, and I'm sure you'll notice there's a push here for proactive behavior when it comes to detecting issues. So the benefits of the program, in my view, really at a high level are twofold. First one is that it prevents erroneous claim submissions that could lead to overpayment. And it also makes it more likely that you'll detect fraudulent conduct before it happens. So again, you're looking at two things. One, you're likely to catch something when it does happen. You're also more likely to catch something before it does, if you're, for example, conducting routine audits on billing and things of that nature. A third benefit, as I mentioned, could also be that the government, again, does look upon the implementation of a compliance plan when determining penalties after an issue has already arisen. A couple of other things, they improve business operations. Again, we covered this in a prior discussion using, for example, a billing company as an example of not only assistance with compliance, but also efficiency in billing. This is a similar application here. It can help you optimize your proper claim submission, minimizing billing errors, reducing your chances of an audit. Again, you're going to catch something before it becomes an issue or a bigger issue, and you're more likely to overall be compliant with applicable fraud and abuse laws for the same reasons. You're watching this, and your employees, from your owners all the way on down, are paying attention to compliance in general. It enhances patient care for the same reasons. So let's talk about actually building the plan. The plan should consider the financial and staffing resources available to the practice. One thing that we lawyers try to say is try to stay away from Google. I always say, think of the patient that comes in with a bunch of printouts from WebMD having self-diagnosed. It's kind of hard to get them off of that mindset. Well, it's a similar thing here. If you, for example, and I've seen this before, I have seen Specialty A show me a compliance plan that they tried to put together, and it's clearly tailored towards Specialty B. That is not the kind of thing the government wants to see. In fact, a large medical practice client of ours had a compliance program that they hadn't mentioned to us that we found was even complete with the blanks where the practice name was supposed to go. That's not the kind of thing you want to see. You need to be sure that you're sensitive to not only the financial and staffing resources, but your practice in general. It's important. These are not just fill-in-the-blank type things. They're actually, when designed properly, are tailored to the operations of your practice. So one of the first things that we do in my world is actually to take time and interview not only the owners of the practice, but particular employees, to make sure that we have an understanding of operations, of types of services, and that cover all of the bases associated with the operation of the practice from a compliance perspective. That last bullet there, that the plan should be user-friendly. Remember that this is something that isn't necessarily going to be stashed away all the time. This is something that new employees are going to be trained on. This is something that, this is a living document, so to speak, and that this is something that if there is a problem, you want people on your team to bring to you conduct that they believe raises red flags. So you want something that people can understand. It's sort of, I take my lawyer hat off and put my human hat on sometimes when I'm drafting these to make sure that we're making them user-friendly. Let's talk a little bit about the attention that the OIG pays to erroneous claims versus fraudulent claims. And I'm sure you can imagine they look at an erroneous claim with a little bit less of a sharp knife than they do a fraudulent claim. There's this little thing called intent there. OIG acknowledges that a majority of physicians are ethical, they render high-quality care, and they submit proper claims. They do realize that accidents can happen, that somebody can have a misunderstanding. Those are the types of things that usually fall into the realm of civil penalties, financial penalties. As much as we all like to make sure that we keep the money that we make, it's a heck of a lot better to have to pay back money than it is to give up your freedom by going to jail. So the government does make clear that they, although they do seek out erroneous claims, they don't necessarily treat them the same way, of course, as fraudulent claims. In a prior discussion, we of course talked about the False Claims Act. It has a criminal component, but it also has a civil component. Using an erroneous claim as an example, the government would multiply the damages, meaning the value of the claims associated with whatever issue, and multiply that number times 3. That's a civil penalty. And again, that government's focus on that when it comes to erroneous claims. Fraudulent claims, of course, can involve criminal penalties. That's when you've got actual knowledge, you've got intent to defraud the government or intent to defraud the insurance company. Can also be the same kind of thing with insurance fraud. That's criminal intent. When you've overtly attempted to defraud the other side, that's when you're looking at bigger criminal penalties. So the building blocks of the compliance program surround erroneous claims. There isn't much you can do with your compliance plan when you've got active fraud. Of course, it is designed to catch active fraud, but that is not a good thing for the person who committed the active fraud. So let's focus a little bit first on erroneous claims. The guidance that the OIG put out sets out specific concerns and areas within the compliance plan to deal with erroneous claims. And this is an example of the list of items that the compliance plan should include when it comes to erroneous claims. When you think about it, again, this is a very specific, detailed, nuanced area that's constantly changing when it comes to billing and coding. These are the types of things that, as I'm sure you can imagine, you want to have within your practice operations anyway, to make sure that you're not consistently in the business of paying the government or insurance companies the money that you've been paid for the services that you've provided. These things can turn on the split of a hair when it comes to, I always use an example of evaluation and management codes. So for office visits, two reasonable people can differ on whether the service provided and the documentation associated with it in the medical record supports a level 3 or a level 4. There's not necessarily a huge distinction between those two. If it's not in the record, it didn't happen. So, of course, documentation is very important, but so too is the idea that you need to support it with your documentation such that you keep your money. These are the type of things that are components that are going to help you be able to do that. Internal auditing and monitoring, constantly making sure that what is being not only done from a compliance and operations standpoint, but from a billing standpoint, matches the law as it evolves. Now, of course, you want to make sure that you don't have too many obligations. That's the dance that people like me help clients dance. You don't want to have such a robust plan that it's got too many rules to follow, because all that means is you're setting yourself up for failing to follow some of them. A good example of that would be, in a perfect world, we love weekly monitoring of claims, but that's not realistic. So whether it's quarterly or monthly, whatever fits your practice is something that people like me, again, would discuss with the practice to figure out what fits best, not only from an efficiency perspective, but of course also a cost one. The compliance officer is important. Now that can be the same person. If you're a solo practitioner, that can be you. It can be the office manager, it can be one of the physicians, it can be anybody, but of course it needs to be somebody that you can trust, typically somebody with some longevity in the practice. There might be pieces of information that come to the compliance officer that need to stay confidential and be discussed with counsel, for example. So this is somebody that you want to make sure is close to you, that knows the practice well, that knows the people well. You want to keep open lines of communication. Remember, you want to know what's going on within your practice. You may not see everything. So you want people to feel comfortable. These are often awkward situations if there's a compliance issue. And it's, people's natural inclination to feel like, well, am I going to get fired if I share this information? Is somebody going to hate me? Is it going to get back to the person? You want to do everything you can to sort of blast through those walls so people feel comfortable sharing when they think they see something. That's what's important. You want to stay as close to in front of these issues as you can. So on the auditing and monitoring side, there's that ongoing evaluation process, and you want to be able to, again, determine that claims are being submitted properly and that your individuals are carrying out their responsibilities. Two main ways to do that. You can audit the claim submissions, and you, of course, always want to be auditing your standards and procedures. Your practice is going to grow, it's going to shrink, it's going to evolve. You want to make sure that these standards and procedures, again, match your operations. On the standards and procedures, the OIG has identified 4 risk areas. Not surprising what they are: billing and coding, reasonable and necessary services. That's that gray space again. Two people can argue whether something was, in many circumstances, whether something was reasonable and necessary. I can assure you, I have seen poor documentation and lack of documentation. Candidly, it's rare for me to hear the physician acknowledge that even when I see it, but we do see it. And it is an important space to make sure that your documentation, it doesn't matter what you think it should say, it matters what the law requires it say. And the coding is very, very nuanced, and it's very important that your records support the service you provided and the service you billed for. Very important. That last one is almost a non-starter. Of course, there's a risk area, and you're going to want coverage for illegal kickbacks and self-referrals and inducements. Now remember, that may not apply to the physicians. That may apply to nurse practitioners. That may apply to physicians. It may apply, depending on your practice. It may, if you have sales force, you may not know what other people are doing. And again, that's why this is an important set of documents, this compliance program. And you're going to, again, want your standards to match your operations. It's important to keep this current. Now, it doesn't mean you have to change things weekly. I would say that anecdotally, most of our clients really don't see themselves changing these on a routine basis. Now, sometimes we reach out to our clients to let them know that there's been a change in the law or a change in a guideline that requires a policy change. Other than that, of course, we rely on our clients to let us know if there's a substantial change of some kind within the practice that would necessitate a change within the compliance program. One great example would be a compliance officer leaves and it's time to change the compliance officer. That's one example where you need to make sure you're updating your documents. Most clients mentioned over here, the OIG strongly recommends creating a resource manual or binder. That is something that we emphasize as well. Every single one of our clients that has a compliance plan and program put together ends up with at least one binder, depending on the size. We like to recommend they be at least in every office. Again, solo practitioners, that can mean one. You might want them in multiple offices, even just within the office. All things to consider in terms of how you want to make your culture of compliance look. But again, very important for people to understand that this is a document, a set of documents that's important and that should be utilized. The compliance officer, a little bit about that. I said somebody that's been around, that you're close with, that you trust. This is a very important role. And again, it can be you also. Jobs are oversight of practices' adherence to the plan, development of a corrective action plan if needed, and to manage all the compliance activities, including solutions. Now remember, the compliance officer need not act alone. Most compliance program documents literally require the compliance officer to contact counsel when an issue arises. Of course, it's at the discretion of the compliance officer, but nevertheless, there are several reasons for that. One, first and foremost, because your counsel is the one that's going to be able to assist you with whatever the problem is in terms of being able to analyze whether there's actually a problem and how to properly address it based on the law. Two, there's this fun thing called the attorney-client privilege that's very important. And when the lawyer gets involved, as long as all the elements are met, and that's something that your attorney would assess, the attorney-client privilege can end up applying. And that can basically create confidentiality as it relates to communications surrounding whatever the issue is, and it can leave you, even though you're in a situation where you're feeling like you might not have much control because something bad has happened, it allows you to get as much control as possible about the messaging of the issue. Education and training. So you want to develop a plan for education and training. You need to look at who needs it, the best type of training, and when and how training is provided. These are things like new hires, for example. Are you going to train every new hire or just new hires in certain divisions, such as billing and things of that nature, and sales? So you need to assess that and see what works for your practice in conjunction with the law. That can include the importance of the compliance program and actually going through the standards and procedures. At many of our clients, train every new hire. So as soon as somebody becomes an employee of the practice, part of their training is about compliance, so they can emphasize how important this is to the operation and the safety of the practice. The next phase is responding to an actual issue. It's important to follow up on reports. Typically, these flow to the compliance officer. There's even provision in properly drafted compliance programs that covers what happens if you think that the compliance officer is the one who's at issue. Us lawyers try to think of every single scenario and make sure we cover that base. So we do also cover issues such as that. These are a few of the examples of the type of things, again, types of things we cover when it comes to responding to issues. This, as if I haven't emphasized it enough, is such an important one and many times can be the hardest one to get folks comfortable with, is that open door policy idea. This reporting requirement, making things not only user-friendly but just friendly, that it's okay to share when there's an issue. If you don't have that, I can almost assure you as a physician, you're not going to know what's going on. You're focused on treating patients every day. You're not going to know necessarily what everybody else is doing while they're working at your office. So it's very important for people to keep their eyes open and feel comfortable sharing if they see an issue. And again, that's part of what this is designed to do. Now, it doesn't require them to analyze whether an issue is a kickback. That's for the compliance officer perhaps the physician or physicians as owners and counsel. But you want somebody in a place where if something doesn't feel right, hey, I learned in training that something of value I can't give people money to come here. I think I saw somebody else talking with somebody about that. I want to share that with the compliance officer. At a minimum, that's what you want to be teaching people. The disciplinary standards are important too, sort of the downside of the friendliness. You want to make clear what those guidelines are for consistent enforcement. You want to have those standards in place. Again, the program's going to cover anything like that, but we want to make sure, again, that they match your practice. Assessing effectiveness, that's, of course, an ongoing effort. That's not something you do just at the beginning. It's something you have to constantly be doing, and it's another one of the difficult parts is making sure you stay in front of this, and then, of course, making sure you're adhering to whatever advice there is. A good example of this is hiring an outside coding expert, or if you happen to have one, certified coder on staff, having that individual review codes on a consistent basis. If you don't and you're using a third party, one thing to consider is having your counsel discuss with you and the coding expert whether the counsel will engage the coding expert. The same reason being that the attorney-client privilege could apply to that, such that if the coding expert finds things that he or she doesn't like, you're going to want that to be attorney-client privilege so an assessment can be done as to how to handle that. The last thing you want is for a dispute to arise between the practice and a payer or a practice and a government, and you've got your own coding expert out there telling you how bad your billing and documentation is. That's not something you necessarily want to have out there, so an important strategy item. So in general, again, I emphasize this as many times as I do intentionally, that the compliance program is very important for a few main reasons. One, of course, is minimizing the risk for an audit because you're staying in front of issues before they happen. And two, you're positioning your practice appropriately if an issue arises. Importantly, it hasn't happened yet for physician practices, but we've been waiting. As part of the healthcare reform legislation, nursing homes are required to have it. And there is language in the healthcare reform legislation that asks the Secretary for Health and Human Services to consider which other healthcare providers are also going to be required to have them. I think it would be foolish to think that at some point they're not going to require almost everybody who's a Medicare provider to have it or something of that nature. As fraud and abuse continues to be a huge issue and the amount of money that's spent by the federal government on Medicare and the provision of services to Medicare beneficiaries continues to increase and the number of Medicare beneficiaries continues to increase, it stands to reason that the compliance is going to continue to become the massive issue that has already become, and this is one area where the government I could see potentially requiring even more healthcare providers implement compliance plans. So as I mentioned at the beginning, having one and not adhering to it or having one that doesn't match your practice is probably worse. We have been in situations, as I've said, thankfully I have not seen it where the government has seen what I've seen. That would not be good. But they don't like to see lackadaisical behavior. They don't like to see, oh yeah, we have one, here it is. And clearly, even though you're an endocrinologist, you have a radiology compliance program. They don't like to see that because it shows in their mind you don't care. So making sure that one, you have one that matches the operations of your practice, and two, that you're adhering to it is very, very important. And as I mentioned a few times, the government looks at these very favorably if you've got a problem. In fact, some of the statutes, such as the self-disclosure protocol for the anti-kickback statute and for the Stark Law, which again would be the type of things that a practice would catch if they're implementing their compliance program. Let's say you catch a kickback on one of your employees, for example, and you have to return money associated with all the claims that were associated with those kickbacks. You would do that potentially under the self-disclosure protocol, the federal government's self-disclosure protocol for kickbacks. Well, believe it or not, the penalties associated with the self-disclosure protocol are actually lighter than if the government catches you doing it instead. So you can see that they've actually tailored these laws. So if you were to do a timeline here, you've got your compliance program in place, you're routinely auditing the operations of the practice, you discover a kickback, you return the money, I'm oversimplifying this, of course, and you do it pursuant to the OIG self-disclosure protocol for kickbacks, you're subject to more lenient penalties than if the government found out about it on its own. So very important. Another component that's become more significant over the past few years is the new, relatively new at this point, Overpayment Refund Law. That was also part of healthcare reform. It basically requires any Medicare provider to return within 60 days of knowledge in overpayment. What does knowledge mean? There's a lot of tinkering that goes on in there by us lawyers, but generally it's sort of a known or should have known. I know this feels like the kind of thing you'd want to bury your head in the sand about, but that's actually not the case. The case law that's starting to come out about this shows that the providers that kept their heads in the sand and that should have known about this or were notified by billing companies or their billing departments and ignored it ended up getting in trouble under this new law. So keeping your head in the sand is not okay. So if you're implementing your compliance plan and you're handling it properly and you discover something, it starts the clock on a refund. Now, again, there's a lot of nuance that goes on in terms of when the clock actually starts. That's something that should be assessed by you and your counsel together. However, it's important to know that these laws are in place. There's actually a component that says that if you violate this, you're violating the False Claims Act because you're knowingly holding on to a payment that you shouldn't have. And that can subject you to criminal penalties and to that, again, 3 times the damages civil amount. So serious law here that came about as part of healthcare reform. And this, again, I keep referring to this culture of compliance, and you get a sense of how important it is and how you can implement it into the day-to-day operations of your practice to minimize the risk that money has to go back to the government or to your insurance payers. It's absolutely essential. I could scare you with hours of stories that I've experienced for clients and with clients, but just trust me instead. But it's very important for everybody to understand, everybody in the practice to understand how important all of this is, to keep their eyes open, to understand how important the culture of compliance is too. One of those bullets on there, you'll see that physicians make mistakes too. That happens in the billing world. It also happens when just poor decisions are made sometimes from compliance. It's also unintentional often. I'm not a criminal lawyer, as I've mentioned, but I can assure you that sometimes good people end up in bad situations because these laws are very easy to violate, even unintentionally. So that's why it's important to make sure that your advisors are there to assist you and that you're in front of these things and you know when to ask. It's just like being a good patient when you think about it.